This is Michael Popok, and based on these glasses, it must be time for Legal AF After Dark. What is the criminal justice system, state and federal, including Judge Chutkan in the D.C. election interference case? What are they doing since they've gotten their instructions, as muddied as they are, from the U.S. Supreme Court against Donald Trump? How do they bring him to justice? And what is the special counsel doing about it? And why is it taking him so long in order to let the judge know how she should be applying the immunity decision to the D.C. election interference case? Do I got your interest now? Are you interested? Do you want to have explanations? Here we go. Take a listen.
All right. Tell us, though, Popok, what's going on before Judge Tanya Chutkan, the Washington, D.C. Federal criminal case against Donald Trump for trying to overthrow the results of the 2020 election. That's the case which went to the Supreme Court after first Judge Tanya Chutkan denied Donald Trump's motion to dismiss on absolute immunity grounds. Trump appealed to the D.C. Circuit Court of Appeals. They unanimously, both Democratic and Republican appointees, following what the actual law was, said, no, you don't get absolute immunity. Denied. Donald Trump went to Neil Gorsuch, who we saw earlier in the show, the right-wing Supreme Court justices, 6-3 decision. They said, yeah, absolute immunity. Not only that, you get absolute immunity for official duties. We should get a strong presumption that everything you did while in office, even things that were like notoriously things that were not permitted, like ordering the DOJ to do things when you are the president, when there's supposed to be a separation. Yeah, you get immunity for that. And there's evidentiary immunity where people can't even introduce any evidence at all regarding official duties or official acts at the time of trial. So immediately, when we talked about this on the last show, Judge Tanya Chutkan, who's presiding in the district court, when she got the case back from the Supreme Court last Saturday when we were doing Legal AF, she issued 2 orders right away, order after order, denying Donald Trump's motions to dismiss. She set a status conference promptly, and she requested briefing by the parties on what do we do next now that the Supreme Court made this absolute immunity argument. Special counsel Jack Smith filed a joint status report along with Trump's lawyers. It was unopposed. It was a stipulation, one of the first times we've seen them stipulate and agree to anything, to move these dates back by a few weeks. And then Judge Chutkan issued the following minute order as to Donald Trump, the criminal case. The government's unopposed motion for an extension of time is hereby granted. The joint status report, where they were going to address the issues of absolute immunity that the Supreme Court ruled on, that was first due on August 9th, 2024, is now due by August 30th, 2024. The status conference previously scheduled for August 16th is continued until September 5th, 2024, after Labor Day at 10 a.m. in courtroom 9. What do you make of this, Popok?
Well, let me jump off sides here, because this is what I think is happening. Not jump off sides from you, just sort of the common consensus here. Jack Smith needs more time for 2 reasons, and I think it was a wise decision for him. One of them is he has to consult with all of the various civil and criminal divisions of the Department of Justice, this giant Leviathan machine that we call the Department of Justice. He has to consult with all the heads. Right now, there's a lot of emails and memos going around. There's a lot of conferences and calls, because it's not just about Donald Trump. It's about past Jan 6 insurrectionists, future Jan 6 insurrectionists, cases we haven't even thought of, cases they haven't even thought of that could happen in the future, and how the ramifications of taking a position under this immunity decision will impact the Department of Justice for a long time, for the foreseeable future, for generations. So it's a really hard decision they have to make, and they need more time, despite the fact I'm sure they've been working on this since the July 1st decision came out, and or the decision in Fisher versus the United States came out, in which 2 of the counts, obstruction of an official proceeding, were kind of imperiled by that decision for Donald Trump, or at least there now has to be an argument to save it. That's one. Secondly, though, I think that what we're watching is, because the July 1st decision by the United States Supreme Court was so lawless, was so unhinged, was so untethered to an appropriate analysis, was so slapdash put together by Chief Justice Roberts and trying to put together some coalition of the right-wing willing in order to side with Donald Trump, against all of this infighting going on in the court. Of course, all glossed over by Gorsuch in your Fox interview clip today. It just shows you how difficult the quote unquote precedent and requirements that they have now put on the government and put on Judge Chutkan are to apply. It's not an easy decision because it's almost impossible to follow. You gave a perfect example. The core, I know what core presidential powers are under Article 2, and I know where to look for them. They're in the Constitution. And generally, the conversations that a president has with somebody in the Department of Justice is not generally considered core presidential function. It could be considered official conduct stretched to its outer boundaries, for which it is a rebuttable presumption that it has immunity under this decision. But generally, that conversation between Donald Trump and Jeff Clark, where Jeff Clark said, hey, I have a way to overturn the will of the people. I can put something on Department of Justice letterhead and throw a monkey wrench into Georgia and other states' certification of the election and claim that there was fraud in the election when there wasn't. And Donald Trump said, great, can you get it out now? And he goes, yeah, I'll write it right now. That would be, in my view, official conduct at best. But no, in the order, they said, and we'll give you an example, and we're going to take it off the board right now. Conversations between the president and Jeff Clark, absolute immunity. I'm like, okay. It didn't make sense from the teachings of the decision, from the ratio descendi, as we like to say, the Latinate way of saying the kind of the logic of internal logic of the decision or the case law or the precedent. By the way, as we all commented back in the day, and that day was July 1st, this opinion was woefully lacking and light on precedent analysis and case law. And they had all the greatest hits. They throw in the one-liner about no man is above the law. And then the entire opinion was about putting one man, Donald Trump, above the law. And so because of that, it's very difficult for Jack Smith or anyone to map this decision onto the indictment, because it's all a mess. It's all gobbledygook on purpose. It's so opaque. And so that's what they're having problem with. So they got to take a position. It's not just about, we'll get back to you about how we want to brief this. They're trying to come up with what is their good faith analysis for the best position, and like a good pool player, to set up the next shot. Not just in this case, but in other cases. All right, so that is the delay. And that's what we watched writ large with the request for 3 more weeks. Of course, Donald Trump was like, a delay? I'll take at least one of those. And so he was like, great. And the judge was like, okay, I get it. It's hard. And you're a Department of Justice. You're not just a guy. That guy was like, he'll come up with his opinion. It'll be 2 lawyers. They'll come up. But the Department of Justice has bigger fish to fry. And that's what we're watching. So the good news is, there's going to be a hearing on September the 5th, right after Labor Day, when the judge gets back from vacation and all of that. She's cleared out the underbrush in the meantime by denying the motions that were all filed seriatim, all in order in October of last year by Donald Trump on various grounds of motions to dismiss. She's like, forget all those. And some of these I don't even want to deal with until after I decide about immunity. Now because the hard work is the following, and then I want to backpedal on something you and I talked about last week, or I want to give another review. She's got to take this indictment and she's got to pass it through, whether you think of it like a meat grinder, a cheese grater, or a filter. But she's got to shove this indictment through the directions of the United States Supreme Court and see what comes out the bottom. Is this going to be a Swiss cheese indictment that there's nothing left of it because of the overt acts between the evidential immunity part of it and the absolute, and once you apply all these, what's left? And I don't think now Jack Smith's going to raise his hand and say, we'd like to re-indict. We'd like to go back to a grand jury and re-indict and then try to comply with what the Supreme Court wants. I think they did the indictment so surgical, because you and I always talked about comparing this indictment to the speaking indictment of Fani Willis, for example, which was sweeping and went on for pages and hundreds of allegations, dozens of defendants about things all over the United States that happen even outside of Georgia. That's not what Jack Smith did. Jack Smith knows the Supreme Court is is constituted the way it is. And I think was very surgical and mindful for another reason here. So it would survive any kind of wacko immunity argument that came out of the Supreme Court, which it did. So I think he stands on solid ground on his immunity, on his indictment with the immunity decision. He makes that argument. As to the evidentiary hearing, I'm not sure, A, it's permitted, or B, it's necessary. And here's my theory on that. The indictments who come out of the grand jury, right, have to rise and fall on what is in the indictment. If there was another fact that should have been put in there, you can't supplement it now in a brief. You can't supplement it now in a hearing. If there was a great argument that was made at the grand jury proceedings, which are still secret, you can't say, hey, judge, read the transcript, supplement and annotate. And no, this thing has to be what it is, given the law the way it is. So while I would love a mini trial, I just don't see how an indictment, which can't be amplified, supplemented, or amended through anything else other than what the grand jury issued, is going to be, I don't see how you're going to get a mini trial where evidence and witnesses and Mike Pence comes in and this and that, because this thing's got to rise and fall on its own merits. And while the Supreme Court chastised, and we all believe wrongly, Judge Chutkan about, oh, you should have done this at the beginning. You should have done a fact finding and immunity analysis at the beginning of the indictment stage and not at the end. And that was your major problem, but gave her no guidance on how to do it. And she's going to have to work it out with this briefing schedule. I don't see an evidentiary hearing. I see major briefing, 3 briefs in total, which maybe she gets completed by the end of September, beginning of October, and then she issues a ruling. But the reason we don't see a hot and bothered Jack Smith with his hair in fire about timing, nor do we see it in the 11th Circuit on Mar-a-Lago and Cannon, is because he's sort of he sees the clock and he sees the calendar, and he knows that he's never going to get either cases up and running to get tried before the election, let alone before the inauguration. So an extra week here or there. That's why I think he's left the 11th Circuit briefing alone in Mar-a-Lago with Judge Cannon to get that case back, and has accepted basically the briefing schedule that put it into early September and October. And then I think he's done the same thing here. So we're not watching him defeated, but we're watching him being a realpolitik realist about what he can accomplish and what he should accomplish and the importance of it. If we're right, I'll leave it on this. If we're right about Kamala Harris winning and becoming Madam President-elect, such sweet music to our ears, then all this timing issue won't even matter. The Department of Justice will stay intact, maybe headed by another attorney general. The special counsel will stay intact, and the cases will continue against a failed, shrunken criminal Florida man in Donald Trump.
We still have the sentencing in the Manhattan District Attorney criminal case set for September 18th. Justice Merchan said, come hell or high water, we are doing a hearing that day. So you could do all your procedural maneuvers. There will be a hearing on September 18th. Also, Donald Trump is a very good counter indicator, and everything that he does, just do the opposite. So in fact, when Donald Trump wanted delay, it may have actually been in his benefit to have all of the criminal trials one after the other, because it's the only time he's able to actually stay on a message. Now, his message is totally false and defamatory, but when he has the criminal case, he comes up with the 4 things he says about the judge. Oh, it's the judge's daughter. Oh, Mar-a-Lago's worth $8 trillion and not $27 million, even though Donald Trump said it was worth $27 million to pay less taxes. Or, have you seen Justice Engoron? Have you seen this guy? He's a crazy guy. He hits the same points. And the corporate media doesn't give a crap if he's found liable for felonies or sexual assault or whatever it is. So, look, I think the fact that you don't have these criminal trials right now, and we're able to see what Donald Trump's saying in Montana, what Donald Trump is saying in Harrisburg, Pennsylvania, what Donald Trump is saying at the National Association of Black Journalists, people can see who this individual is, talking about Hannibal Lecter getting eaten by sharks, talking about bellies, strange behavior that is so outside the orbit of any just normal political discourse, yet alone articulating coherent political theory. But it's why I wanted to start with at the beginning of this episode to say, look, Trump's been found liable of felonies. He's a convicted felon. He's been found liable for sexual assault. The Trump organization as an entity is a felon organization, and Donald Trump has been found civilly liable for fraud. All of that has happened. And if we were to ask our viewers, did you think that was going to happen? Would we be in a place with August where all of those things were true? You would say, no, there's no way all of those things were going to happen. But then if I told you those things were going to happen, you'd probably say, well, then he's done. How can you possibly survive in a political climate where you're a felon, you've been found liable for sexual assault, your organization is a felon, and you've been found liable for $500 million, and that's just the tip of the iceberg? Well, that goes to a broader conversation about the corrosiveness of our media landscape that normalizes this behavior and the complete capitulation of the Republican Party that has hoisted up this authoritarian wannabe WWE cosplay fascist on we the people, which we now see the antidote to that seems to be joy and happiness and spreading love. And that's actually one of the things, too, which I thought should never be political, but reclaiming the flag, reclaiming patriotism, chants of USA, USA, out of love and happiness and not anger. That's a powerful force right now.
Welcome back. We call that Legal AF, and now you know why. It's every Wednesday and Saturday at 8 p.m. Eastern Time, right here on this MeidasTouch network. Free subscribe. We're going to get to 3 million free subscribers with your help before Labor Day at this rate, which is important because we have no outside investors. We're completely independent. We are the network you've been looking for, and we're doing this completely by people power, by Legal AF and Meidas Mighty Power. And we do that podcast every Wednesday and Saturday. We curate the top stories at the intersection of law and politics, and we bring it to you the only way we know how, not blowing smoke or sunshine, completely unfiltered, uncensored, just telling you exactly the way it is. It's not that we're never wrong, but we're almost never wrong. In any event, if you know everything you need to know about Legal AF and you're part of the audience, we thank you. Help us with word of mouth, organically grow this. Send that clip off to people in your life and ask them to join our show. And if you don't know anything about Legal AF, but you know other content on the MeidasTouch network, that was Legal AF. I'm Michael Popok, and I welcome you personally to join us Wednesdays and Saturdays for live recordings of the Legal AF podcast on this YouTube channel at 8 p.m., and then you can pick us up on any audio podcast platform. Just plug in Legal AF. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.